The long journey of demanding that right to die is falling under right to life as provided under Article 21 of the Constitution of India and the demand to decriminalize Section 309 of Indian Penal Code which punishes for attempt to commit suicide and the demand for passive euthanasia lastly achieved its victory after a 32-year journey in different high courts and Supreme Court. The judgment relating to right to die is falling under right to life and decriminalizing Section 309 of Indian Penal Code and legalizing passive euthanasia was declared in the important landmark judgment delivered in 2018 in the leading case common cause Registered Society vs. Union of India. So, in this very introduction, we will discuss about right to die with dignity, how it is falling under right to live with dignity as provided under Article 21 of the Constitution, and also regarding advance medical directives by the patient or the living wills, and how it is falling under right to privacy. So, this petition was brought by Common Cause Registered Society, which sought a declaration that the right to die with dignity formed a part of the right to live with dignity under Article 21 of the Constitution. It further sought direction to the state to adopt appropriate procedures to allow persons who were of deteriorated health or who were terminally ill to execute advance medical directives or living wills. The court extensively considered Indian and international precedents, including the decision in case Puttuswamy vs. Union of India, a judgment delivered by the apex court in 2017, which held that the right to die with dignity was a fundamental right under Article 21 of the Constitution. The court also validated the use of advanced medical directives, noting that through this mechanism, individual autonomy could be safeguarded in order to provide dignity in death. The court discussed the development of the right to privacy in some detail, noting that privacy is essential to human dignity, without which liberty cannot be actualized. The right to privacy was also considered central to bodily autonomy, integrity, and freedom of choice, which would then be protected as fundamental rights. In balancing state interest and individual privacy, the apex court note of the US decision in the landmark case decided by the United States Supreme Court in Queensland, which suggested that as bodily integrity was increasingly violated and chances of recovery lessened, the right to privacy increased and the state interest dimmed. So, in that context, the apex court, who find that continuing treatment against the wishes of a patient is not only a violation of the principle of informed consent but also of bodily privacy and bodily integrity that have been recognized as a facet of privacy. So now we'll discuss about the very facts relating to this landmark judgment that Article 21 and right to die with dignity and the decision of P. Rathinam and Nagbhushan Patnaik vs. Union of India case decided in the year 1994, then Gankor vs. State of Punjab case of 1996, and Aruna Ramchandran Senbach case of 2011 and right to privacy and the important landmark judgment relating to right to privacy. Justice retired K.S. Swami case of 2017 show this petition sought a declaration that right to die with dignity fell within the fold of right to live with dignity under Article 21 and to ensure that persons of deteriorated health or terminally ill could execute a living will or an advance medical directive. While this case was initially placed before the three judgments in light of contradictory precedents in determining the law relating to the right to die in India, it was referred to a constitution bench. The issue can be traced back to the case of P. Rathinam vs. Union of India, 1994, in which a division bench of the Supreme Court held that Section 309 of the Indian Penal Code, which criminalized attempting to commit suicide, was unconstitutional as it was violative of the fundamental rights enshrined under Article 14 and 21 of the Constitution. The court held that the right to die was encompassed within the right to life. This was overturned by a five-judge bench of the Supreme Court in the case of Gankor versus the state of Punjab in 1996, where the court held that the right to live does not include right to die, as provided under Article 21 of the Constitution of India. Finally, in the case of Aruna Ramchandran Senbach versus Union of India in 2011, the court allowed for passive euthanasia under exceptional circumstances under the strict guidelines laid down by the apex court. So now we'll discuss the issues involving this important landmark judgment, that is, in particularly right to die with dignity, and as it is falling under Article 21 of the Constitution. Whether the right to die with dignity was a fundamental right within the fold of right to live with dignity, guaranteed under Article 21 of the Constitution. Now we'll discuss about those arguments led by the petitioner, in particularly individual autonomy, right to privacy, and permanent vegetative state and medical treatment without consent. So, the petitioner argued that the concept of sustenance of individual autonomy was inherent in the right to privacy and also formed a part of conception of liberty. It was submitted that keeping a patient in a persistent vegetative state through advanced medical methods, prolonged pain and suffering, and allowed intrusion upon the patient's autonomy and dignity. The petition further claimed that the right to die with dignity was linked to the right to live with dignity. It also pleaded that to refuse unwanted medical treatment was a common law right and that a person could not be forced to take medical treatment without their consent. So now we'll discuss about the arguments laid down by the respondent that right to die with dignity does not include right to live with dignity as provided under Article 21 of the Constitution of India. So the respondent, the Union of India, and the state in its counter affidavit submitted that the state had considered regulating euthanasia, but the Ministry of Health and Family Welfare found it unfavorable. The respondent argued that right to live with dignity, guaranteed under Article 21 of the Constitution, referred to the dignity of food, shelter, and health, and did not include the right to die with dignity. So, now we would like to discuss the very judgment delivered by the apex court. As it relating to right to die with dignity falls under Article 21 of the Constitution, and it is associated with the right to privacy as determined under the landmark judgment delivered by the apex court in the leading case K.S. Puttaswamy in 2017, then also court examined regarding advanced medical directives as a part of right to self-determination. So in that context, the court examined the Quinlan case of 1976 decided by the New Jersey Supreme Court of United States of America. Then also discuss the British vs. United Kingdom case decided by the European Court of Human Rights. So the court reaffirmed that right to die with dignity was a fundamental right as declared. So, whereas passive euthanasia is the act of withdrawal of life support, it held that the court in Aruna Sandbag had erred in holding that passive euthanasia could only be introduced through a legislation in relation to the very topic of living wills or advanced medical directives. The apex court held that there was clear indication of the acceptance of the concept of advanced medical directives in this country. It further stated that the right to execute an advanced medical directive was a step towards the protection of the right to self-determination and bodily integrity. In the case of patients who were unable to take an informed position on the matter, the best interest position could be applied, allowing a guardian to step in and take this decision on their behalf. The case extensively discussed the right to privacy as explained in the case of retired Justice K.S. Puttaswamy vs. Union of India, which was decided in 2017, and its relation to autonomy and liberty. The court relied on excerpts from all 6 judgments in this case, in addition to Indian cases. The court also examined judgments from foreign jurisdictions and discussed the very relationship between the right to privacy and its implications for euthanasia. So the apex court in this landmark judgment relied upon the judgment in Quinlan case decided in 1976 by the New Jersey Supreme Court, where it was held that as the prognosis of patients dimmed, the state's interest grew weaker, and the right to privacy of the individual with respect to their bodily autonomy grew stronger. If the individuals themselves were not in a position to assert their privacy, this could be done by a guardian on their behalf. The court also relied upon the judgment delivered by the European Court of Human Rights in the leading case, Treaty vs. United Kingdom, where the court concluded that an individual had a choice to avoid what they consider an undignified and distressing end to their life, and that such a choice would be guaranteed under the right to respect for private life under Article 8, Clause 1 of the European Convention on Human Rights. So finally, the apex court find that the right to privacy mandated safeguarding the integrity of individual choice in the intimate sphere of decisions relating to death and held that the protection of these rights was an emanation of the right to privacy as they were related to the fundamental right to life and personal liberty guaranteed by the Constitution. So finally, the bench, led by the then Chief Justice of India, Justice Deepak Misra, permitted passive euthanasia and decriminalized Section 309 of the Indian Penal Code and allowed right to die with dignity and declared that it falls within right to live with dignity as provided under Article 21 of the Constitution, as it is a fundamental right falling under Part 3 of the Constitution of India, deals with right to life and personal liberty. So finally, after 32 years of journey, we started with the landmark judgment of Bombay High Court in the leading case, Maruti Sripati Duval vs. State of Maharashtra. And ultimately it landed in another landmark judgment, that is State vs. Sanjay Kumar Bhatia. In 1994, the judgment delivered by the Delhi High Court, then it was again raised in the important landmark judgment, that is relating to P. Rathinam vs. Union of India in 1994, then the landmark judgment delivered by the Apex Court overruling the judgment delivered in P. Rathinam and Nagbhushan Patnaik case of 1994, by the 1996 judgment delivered in Gan Kaur vs. State of Punjab, and finally also to some extent in the landmark judgment of 2011 in Aruna Ramchandran Sandbag, the court permitted partially passive euthanasia under the very guidelines issued by the Apex Court. But finally in 2018, the landmark judgment relating to common cause registered society versus Union of India, the court finally allowed that right to die with dignity falls within right to live with dignity as provided under Article 21 of the Constitution. And in that context, court emphasized that it falls under right to privacy as it was decided in 2017 in that landmark judgment, retired Justice K.S. Puttaswamy vs. Union of India. And finally, the Apex Court decriminalized the very provision of Section 309 of Indian Penal Code and declared it is unconstitutional. So, the very landmark judgment finally permits passive euthanasia and right to die with dignity falls within right to live with dignity as provided under Article 21 of the Constitution of India.